What is happening right now in the federal courts is enough to make your blood boil. We've had a monumental win. The tax on suppressors and other items under the National Firearms Act, the NFA, has been slashed down to $0, thanks to that one big, beautiful bill that passed earlier this year. That tax, the $200 stamp, was the primary constitutional hook the government used to regulate these items. So, logically, when the tax vanishes, the entire regulatory structure should collapse like a house of cards, right? Well, hold on to your hats because the establishment, even elements within the Trump administration's Department of Justice, are digging their heels in. The Department of Justice, under the current watch, is actively arguing against the full dismantling of the NFA. Now, they are being joined by a chorus of anti-gun cities, names you know, Baltimore, Columbus, even Harris County, Texas, who claim that removing these restrictions will unleash chaos on their streets. We're going to peel back the layers on these legal filings, show you exactly why the DOJ believes the NFA is still valid despite the zero tax, and expose the dangerous precedent this sets for every single one of your fundamental rights. We are talking about the very definition of regulatory overreach, and if they win this one, they'll be coming for the rest of your freedom before you can say Second Amendment. Let's start with the facts on the ground. You know the story. The big fight led by groups like GOA, FRAC, Silencer Shop, and Palmetto State Armory finally secured a massive victory. That $200 NFA tax is gone, effective next year. $0. Common sense tells us that when the federal government loses its footing on the taxing power justification for regulating ordinary citizens' property, the whole structure should come tumbling down. The whole basis of the NFA, in many ways, rested on that excise tax levied under Congress's taxing authority. But what does the Department of Justice, represented by Pam Bondi, do? They continue to defend the NFA's remaining restrictions, the registration paperwork, the transfer requirements, all that bureaucratic red tape that makes owning a legally manufactured suppressor or a short-barreled shotgun, an SBS, an absolute nightmare for law-abiding Americans. They filed a brief arguing that even with the tax gone, the statute remains valid. Listen to what this fella just said in the filing. They claim it still imposes a special occupational tax on manufacturers, dealers, and importers. Now, I've been around long enough to know how these government lawyers twist words until they scream. They are trying to argue that because there's still a phantom tax on the industry, the folks who make and sell these things, that somehow gives them the right to keep infringing on the individual's right to own them. It's like saying they can require you to file an environmental impact report just to buy a bag of fertilizer, because the fertilizer manufacturer has to file paperwork. It makes no sense. The plaintiffs, bless their hearts, moved for summary judgment, meaning, Your Honor, the law changed. The tax is $0. Read the statute. This case is over. You can end the litigation right now. But the DOJ decided to drag this thing out. They are also citing the Commerce Clause, claiming the NFA attaches to every stage of interstate commerce, from the factory floor in Arizona to the dealer's counter, all the way to the individual purchase. They want the court to believe that regulating the transfer of a legally made item between two citizens in the same state falls under their interstate commerce authority, just because the thing might have crossed a state line once on its way to the store. This is where you have to stop and ask, who benefits from this bureaucratic molasses? It certainly isn't the millions of law-abiding hunters, sportsmen, and collectors who just want their property without federal babysitting. This defense by the DOJ, which has historically defended these controls, suggests a deep institutional comfort with the status quo of control. They don't want to set a precedent that says, if Congress removes the hook, the regulation falls. They want that hook to be replaceable, interchangeable, like spare parts on a beat-up old Ford truck. Now, if the Trump DOJ defending the NFA wasn't enough to make you scratch your head, brace yourself for the next development. Who else has jumped into this legal fight? a whole squad of anti-gun cities, Baltimore, Columbus, Ohio, and yes, even Harris County, Texas, places that have been fighting tooth and nail against Second Amendment rights for years, are filing an amicus curiae brief, a friend of the court brief, in support of the DOJ's position to keep the NFA restrictions intact. I'll tell you what, seeing Everytown and Giffords cheering on the DOJ's legal strategy is one thing, but seeing local governments, elected officials in cities, actively arguing against deregulation on items that are currently legal, that's a whole different kind of snake oil being sold. What is their argument? Public safety, of course. They claim that striking down the NFA registration and transfer requirements will make it easier for these items, suppressors, short-barreled shotguns, to circulate untracked, leading to criminal misuse that will plague their metropolitan areas. They paint a picture of chaos, of officers suddenly unable to do their jobs because they can't pull up a federal registration form on a suspect they've encountered. Theft. They argue that law enforcement relies on this federal registry, this massive database run by the ATF, to identify these items during investigations and fieldwork. If that database goes away, they say, officers lose critical intelligence and face greater risk. Now, let's apply some common sense here. If a criminal is using a short-barreled rifle or a suppressor in a crime, do you honestly believe the first thing the police department is worried about is whether the paperwork for that weapon is current? If the weapon is stolen, or if it's an illegal transfer, which is exactly what the plaintiffs are trying to eliminate the regulatory burden on, the criminal isn't going to turn himself in and hand over his registration card. This is a classic bureaucratic scare tactic designed to keep the regulatory machine churning, regardless of the original constitutional justification. They are leveraging fear to maintain centralized control over property that Congress just declared tax-free. It's a darn shame they feel the need to use officer safety as a shield for outdated federal mandates. So, here is the critical synthesis, the pattern that should make every patriotic American sit up and take notice. We have one side, the plaintiffs, saying, Congress removed the tax, which was the basis for the regulation. Therefore, the regulation must fall. A straightforward, constitutionally sound argument built on the core principle of enumerated powers. Then we have two other groups, the Department of Justice, under the current administration, and anti-gun city governments, who are actively arguing that the system of regulation itself, the registration web, is valid entirely separate from the tax mechanism. They are prioritizing bureaucratic convenience and the maintenance of the ATF's regulatory infrastructure over the plain reading of the new law and the spirit of individual liberty. When the DOJ defends this, they are essentially telling the Supreme Court and the lower courts, look, even if our taxing authority hook is gone, we get to keep the regulatory teeth because it helps us regulate interstate commerce, and it's helpful for police work. This is the dangerous precedent I warned you about. If they can successfully argue that the registration and transfer requirements for NFA items remain valid without a direct tax, what stops them from saying the same thing about other rights? What stops them from saying the requirement to register every semi-automatic rifle under the Commerce Clause remains valid, even if Congress declares a moratorium on new taxes on those items? This battle is not just about suppressors. It's about whether we, the citizens, retain the ability to force the government to justify its controls through constitutionally sound means, or if the government can build a regulatory labyrinth so complex that it stands forever, simply because it's convenient for the administrative state. The fact that the DOJ and these cities are fighting so hard, even after the tax zeroed out, tells you everything you need to know about their long-term goals. They see this registration system as a permanent feature of American life, and they will use any legal lever, the Commerce Clause, supposed public safety, to keep it chained to the law books. The battle lines are drawn, and right now, elements within our own government are siding with those who seek to limit your freedoms. What do you think? Have you seen this kind of bureaucratic stubbornness in your neck of the woods? Does the fact that the DOJ is defending these controls bother you as much as it bothers me? Drop a comment below if this hits home.